Justice, and the Honorable Deputy Chief Justice of the Republic of Uganda, allow me to adopt the protocols earlier observed. And I want to say that I won't say much. I'm a member of the Judicial Service Commission, and as you are aware, our chair is here, and she'll speak on our behalf. I'll only say one or two things. On behalf of, I know you're already aware that I represent a constituency that speaks the language Professor Ngugi wants to adopt at the same time. But let me say I wish to thank the committee led by Professor Ngugi and all members of the judiciary who have contributed a lot to the development and widening of this idea. AJS is a very important step in opening the multi-door approach to justice, which our CJ has continued to push. Ever since humanity moved or took the journey from the Hobbesian state, where everyone was a king and a judge unto himself, it was the pursuit of justice that created that journey. A civilized society is civilized if it respects the rule of law and also ensures there is justice for every citizen, for everyone. And justice is not necessarily just going to court. Justice will be available in our villages. Justice will be available within the communities. And I want to thank the counties for embracing it. Your Excellency, please tell our colleagues at the Council of Governors the importance of this great idea. We have traversed the country as JSC, and we have been shocked by the distances the ordinary villagers have to cover to reach the courts. An example is Mandera. Another one is Turkana. I believe Isholo is similar. Marsabit, those areas of northern Kenya. And even, imagine, Uasin Gishu, you have to go to Eldoret from all parts. It may look like the distances there are very short, because if you are talking about 70, 80 kilometers, you cannot compare it with the 2,000 one has to cover in the northern areas. But nevertheless, we are very grateful for what the counties, the way you've embraced it, together with members of parliament. A number of them have donated space for us. A number of them have pledged the same. Counties like Narok have given us land all over to build, and they are also helping us build others. And now that we have got representation from all the 47 counties, I urge you to go and spread the gospel from Mandera. And of course, I'm sure the details on the no-go areas will definitely be communicated by our able judges. They will guide which areas are protected under the Bill of Rights and other laws as we proceed to adopt the AJS, so that everyone accesses justice, in particular families and communities. There are things you don't need to go to court. We can sort them out, especially land, disputes within the families, disputes within the villages, and several other areas. As I said earlier, of course, I'm not going to say much. I've not prepared any particular speech to say, but I only want to associate with the good work that is ongoing. I only want to urge us to spread this message of AJS. And I want to thank the entire judiciary and all the actors for what they have done, and in particular for ensuring that Kenya remains among within the Community of Nations that respect the rule of law. And that is what has kept Kenya on the path of a civilized nation. Thank you very much, and God bless you. Asante sana.
Thank you very much, Governor. Let's give him a round of applause as he's taking his seat. Now, ladies and gentlemen, we want to invite a special guest, and I would ask us to be all upstanding as we invite our neighbor, our friend, the Deputy Chief Justice of the Republic of Uganda, Justice Richard Butera. Let's give him a round of applause. Welcome, welcome.
Thank you very much. May we sit. Your Lordship, the Chief Justice of Kenya and President of the Supreme Court of Kenya, allow me to adopt the protocol that has been laid out this morning. I'm delighted to join you at this third annual Alternative Justice Systems Conference. I would like to thank Your Lordship, Martha Koome, the Chief Justice of the Republic of Kenya, and the Judiciary of Kenya for organizing this conference that is already successful. I thank you for the warm welcome and hospitality you have accorded us, the Uganda delegation, from the time we arrived here. I thank the Kenyan judiciary and your wonderful protocol officers for the job they have done to our delegation. Wonderful job. I bring you warm greetings from His Lordship, the Chief Justice of the Republic of Uganda, Honorable Justice Alphonse Chingamoyo Winyidolo. He wished he could be here, but failed due to earlier engagements. Our presence here is an illustration of the togetherness, cooperation, and coordination to advance a people-centered approach to justice in our countries and in the region. The topic we are discussing and I'm delivering on is Uganda's approach and a people-centered justice perspective. This is a very timely topic because it comes at a time when we, as the Ugandan judiciary, are reflecting on the findings of research and several studies, including recently 2024, the Hill Report, which reveals that about 90% of the people in Uganda prefer to refer their disputes to the informal justice system. What our courts actually handle is only 10%. This situation has a history to it. In traditional African society, settlement of disputes involved bringing adversaries in the conflict to a meeting usually in the compounds of family or clan heads. The disputes or conflicts may have existed between individuals, family, clans, tribes, chiefdoms, or kingdoms. All these communities had developed traditional, practical, and useful ways of resolving their disagreements. The traditional dispute resolution mechanisms always promoted peace, order, and harmony amongst the people. The elders or chiefs were the main arbiters. The arbiter invited the parties involved to a public hearing. They listened to them and resolved their disputes at the palace courts in a way that was acceptable under their traditions and customs of that particular community. The disputing parties would be involved in identifying the wrong and the wrongdoer or the offender and the offended party. The offender would accept culpability. Most societies encouraged customary reparation as a way of resolving their disputes. The traditional remedies encompassed compensation, restoration, restitution, and rehabilitation. This is the system that our people understood and applied to their satisfaction. The British colonialism introduced their justice system in Uganda by the 1902 Uganda Order in Council. Under Article 15A of the Order in Council, British common law was to operate alongside the native customary law and the doctrines of equity. The 1902 Order in Council introduced the repugnancy clause under its Article 20, which is similar to all our countries in the region. The repugnancy clause was intended to remove customs and laws that were considered inconsistent and repugnant to natural justice and good conscience. The colonial government respected African values so as long as they were in conformity with their own rules of good conscience. English law continued to be applied alongside customary law in the administration of justice, even after Uganda became independent in 1962. Application of the repugnancy clause was essentially retained in our system till our constitution in 1995. The justice system that people were accustomed to was subjugated to the British system that was strange to the people. The people were not enthusiastic to use the British system. They ignored it and continued with their own system. No wonder only 10% of the cases that come to our formal courts. No wonder only about 10% of the cases come to our formal courts. But there is no crisis in the country. People are handling their cases in their informal system that they are used to. Now, our 1965 Constitution brought a new era to the Uganda judicial system. Under Article 126, it introduced the aspect of people-centered justice. The article provides that judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people and in conformity with law and with the values, norms, and aspirations of the people. Now, this provision becomes the basis for promoting people-centered justice in the country. Despite an enabling framework, we, however, still find that we have a number of challenges. These include the growing case backlog in the courts, as the formal system has long processes that makes expeditious disposal of cases rather difficult. The inaccessibility of the courts, physically and economically, the cultural and values disparity between the formal system and the informal system, the public perception of formal justice systems as obscure, inefficient, and too technical, and that substantive laws of formal systems are at times unjust, oppressive, exploitative, and unable to deliver justice to the public expectations. To deal with the above challenges, we are rolling out initiatives that will solve and embark on solving some of these problems. One, we are operationalizing the alternative justice system in Uganda. The judiciary has embarked on alternative justice systems strategy. The objectives of the system strategy are guided by key access to justice goals. These include to serve as an engine for enhancing justice access to all, to serve as a case backlog reduction management measure, to provide for and support the judiciary ADR mechanisms and inclusion of traditional approaches and institutions, to empower communities to appreciate expert-based justice, to localize justice and justice delivery, emphasizing involvement of parties in dispute resolution, to provide ground on which development of ADR at appellate mediation, community mediation can be based, and a number of other objectives. To deal with the above challenges, we are rolling out a number of initiatives. We are emphasizing compensation in addition to or as an alternative to imprisonment for criminal cases. We are encouraging plea bargaining and sentence bargaining for all categories of criminal cases. We are involving victims and considering victim and society interests in determining appropriate sentences. We are acknowledging special treatment of juvenile offenders. We are promoting reconciliation, especially in relation to domestic violence and personal offenses. In the spirit of the 1995 Constitution, Uganda has made efforts in promoting alternative justice systems that have in turn promoted people-centered justice. The other initiative is strengthening ADR mechanisms, particularly court-annexed mediation. In March 2024, the Judiciary of Uganda held a summit on alternative dispute resolution for Chief Justices from the African continent. We shared experiences from other judiciaries. We learned, among other lessons, that success of ADR requires concerted efforts from all stakeholders in the chain of justice. We have involved officials from the Ministry of Justice and Constitutional Affairs, chambers of the Attorney General, the Director of Public Prosecutions, advocates, among others, with whom we need to promote the ADR agenda. In May 2023, the Chief Justice of Uganda commissioned a 9-member committee chaired by the Deputy Chief Justice to spearhead the ADR strategy and pave the implementation of ADR. On the 30th of May 2024, the Chief Justice inaugurated a pioneer team of 72 mediators. These include vibrant retired justices and judges, senior lawyers, and these include senior counsels, and senior public retired civil servants, and a number of elders representing religious communities and other communities. We are starting with a pilot for mediation at the Supreme Court and Court of Appeal, and selected divisions and circuits of the High Court. We have identified convenient mediation rooms at these courts. Appellate mediation is also being piloted at our Court of Appeal Constitutional Court as a pilot. Initially, the court used it to identify cases for mediation. Today, litigants are getting more interested in appellate mediation. Government agencies, corporations, financial institutions have embraced appellate mediation. We are in the process of making appellate mediation rules, learning from our experiences, and we are currently engaged with stakeholders to ensure that the rules are purposeful and acceptable to all of us. We are introducing settlement weeks. The judiciary is planning to hold a settlement week during the month of August. Stakeholders and court users are being sensitized about this activity to ensure that it is successful. Cases where parties express interest, settle them amicably, will be cause-listed and allocated to trained mediators to facilitate the mediation. We hope to conclude many cases in these settlement weeks. We have also introduced small claims procedure. This is where commercial disputes whose subject value matter is not more than 10 million shillings. We have established teams of judicial officers who explain to the public this innovation, which is cheap, faster, and there are no legal representatives when they are being held. We hope these will solve the majority of cases from the small and medium business owners who are anxious to get the disputes sorted out and they go back to trade. Another innovation is pre-bargain. Pre-bargain has been introduced in all our criminal justice system, and it has been incorporated as part of the alternative justice strategy. Some of the challenges that we faced before, including case backlog, high costs and delays in the prosecution of cases, are being handled in this area. In addition to holding court sessions, we also hold court camps where prosecutors, judges, defense lawyers, the whole court move to prison facilities. The prisoners attend and pre-bargain is explained to them, and those who wish to enter pre-bargain volunteer and register, and their cases are handled in the prisons, and they only go to court to record them, and a number of cases have been handled there. The advantage of this is the reduced cost, the number of cases that are done in that session. Most cases are also handled easily because the accused persons participate and agree on the sentence with the prosecution. If it's acceptable to the court, it's registered, and that would be the sentence served. There is growth of jurisprudence in the area of pre-bargaining, and we are streamlining its application. Cases are fast-tracked through this system where the accused persons are showing interest. The interests of the accused, the interests of the victims of crime are catered for because they are allowed a word in the process. There are now more convicts. There are now more convicts than remand prisoners in our prisons since the application of this pre-bargain procedure. We also have introduced support to arbitration of commercial and other disputes in our courts. We are doing this through, we are supporting arbitration of commercial and other disputes in our courts. We are doing this through training of judicial officers in arbitration and give full support for disputes that need to be settled through the arbitration process. We are working closely with the Ministry of Justice and Constitutional Affairs to see that a new ADR policy and law are more supportive to ADR that is in dispute. We have identified convenient mediation processes and individuals that will help us in engineering the alternative justice system to adequately cater for the needs of our people. In conclusion, there is no doubt that our AGL policy and strategy are aimed at bridging the gap between the adversarial and alternative forms of delivery of justice. Alternative justice systems resolutely provide people-centered justice, and we are here to share our experiences, and we are willing learners in this process. Thank you very much for listening to me.
Thank you very much, Deputy Chief Justice. Let us appreciate him. If our neighbors are here and interested, the bankers are here and interested, governors are here and interested, 47 counties are here and interested, must be a good thing, isn't it? You have over 30 judges here and interested. It must be a good thing, isn't it? Asante sana. Now, we are coming to the climax of the opening ceremony, and I would like to invite our host, the Vice-Chancellor, to come and officially invite the Chief Justice to give her opening address. Vice-Chancellor, welcome.
Distinguished delegates, it is now my singular honor and privilege to invite the Honorable Justice, Lady Justice Martha Koome, Chief Justice of the Republic of Kenya, and President of the Supreme Court of Kenya, to address the third annual Alternative Justice Systems Conference. Ladies and gentlemen, a round of applause for the Honorable Chief Justice. And please be upstanding.
Thank you very much. Please, may we be seated. Thank you. Our Vice-Chancellor, Professor Kiplagat, thank you very much for hosting us. We celebrate this great university. We celebrate the founder, the second President of the Republic of Kenya. I believe wherever he is resting in peace, because 10,000 of our children are the ones enjoying this facility. As I stand on the earlier established protocols, I want to thank also our brother, the Honorable Chief Justice of the Republic of Uganda. You bear the same name with my younger brother, Richard Butere, but Ace is Rutere. So you are truly my brother. Thank you so much for coming to grace this occasion. Your Excellencies, the governors of Mandera. I was given a beautiful name in Mandera, Kaitum, a woman of honor. And I celebrate that name. I am also Tapach from Washingishu. Wherever we go, we never leave, we stay there. So thank you so much for traveling great distances to come and grace this third annual conference of AJS with your delegation. Thank you, the Deputy Governor of Nakuru, for hosting us. Thank you all the speakers who have spoken great words of encouragement to the movement of AJS. We are so, so grateful to all of you, judges, my colleagues, and all the members of the clergy from Nakuru and distinguished delegates. A very good afternoon to you. Salaam alaikum. Chemgei. Asante sana. Thank you very much, our MC, Mr. Okello. I think you forgot to say, when you are saying Nakuru is the place where leaders are trained, where they are incubated, you forgot to say the Honorable President of the Court of Appeal was also a judge here. And that is where he cut his teeth in leadership. And today he is the President of the Court of Appeal. You also forgot to say the immediate former CJ, my predecessor, the CJ Emeritus, Mr. David Malaga, also worked in Nakuru and is also a resident of Nakuru. So, nani kama Nakuru? No wonder you are the first county to host the first national conference of AJS, the great people of Nakuru. We also celebrate you. You are a great host to this conference. So I'm very, very encouraged also to just say, as a good lawyer, I adopt all those speeches that have been spoken this morning. I'm also tempted to say nothing, but just declare the conference formally opened. But being the Chief Justice, and because a lot has been spoken about people-centered justice, and last night I was declared a bishop. By the Christian Leadership Forum. I must say something, because a bishop cannot stand on the podium and just say nothing. Yeah, so all those speeches make it very, very necessary for us to understand why we all traveled those great distances. And we are here to see how we can work together, how we can complement each other, and how, like Governor Isaac Ruto has said, we can truly sambasa justice from wherever we are. Because we have been told we are the sovereign, we are the people. And because we are the people, justice belongs to us. And we are the agents of justice. So when we live here, we have also understood the judiciary is complementing what we are doing. We are not sabotaging each other. We are working towards empowering our people access justice. Because justice belongs to all of us. So allow me, first of all, having emphasized that we are not sabotaging anybody. And when I speak like that, I like to celebrate mostly the lawyers, the advocates. Where are the advocates in the house? Thank you very much for turning up in big numbers, because AJS is also supposed to complement your work. It is not taking away your work. We have a very, very good advocate who gives us the example of the food being cooked, and there are many children. But everybody is looking at the pot. They have been given in their plates, but they have not even eaten what is in their plate. They are looking at the pot, whether there is more. The message he sends to the advocates is that we have many cases that are pending in our offices. And if we can embrace the multi-door approach and move them faster, it means we will have more work, because we will be empowering our clients to bring more work. We will not just be milking this one cow, that is this one client. You keep on sending fee notes year in, year out for 20 years. For how long can you milk a cow? It will die. So instead of this one cow dying, the cow will be multiplying. And you'll be having, like we call in Kemero, many tojao, which you can sell, which you can milk. And that is what multi-door approach to justice is about. Multiply, including the clients. Because when we finish their work, they send more work on our way. More people come, your practices become more vibrant. So are we together? That AJS belongs to all of us and leaves no one behind, including our distinguished advocates. So allow me to first of all start by thanking the National Steering Committee on the implementation of the alternative justice system under the able leadership of Justice Professor 𝒍𝒆𝒏𝒈 and his dedicated team, because they have sustained this effort of championing the cause of AJS throughout Kenya and ensuring that this third AJS annual conference has come to fruition, and we must applaud them. We must appreciate the team of Professor 𝒏𝒈. Let us applaud them. Since he took over this responsibility in 2016, Professor 𝒍𝒆𝒏𝒈 has never dropped the ball. And I know how difficult it was to conceptualize what the Constitution meant by AJS. It took us more than 5 years in the judiciary to understand that particular provision of Article 159, what it was meant for the judiciary to promote the alternative justice system. Professor 𝒍𝒆𝒏𝒈 and his team spent many sleepless nights. And this is one agency, this is one task force that has never been budgeted by the judiciary. They have done this work through passion, and see where passion can take us. It has taken us to the 47 counties where we had developed county action plans. It has caught fire in the communities. We have connected with the counties. We have connected with our indigenous organizations. Last night we launched one of the sectors that are going to deal with conciliation, peace, and AJS systems here in Nakuru, that is championed by the Christian Leadership Forum of Nakuru. And we are very grateful. I urge the governor of Mandera, before you return with your delegation, please pay a courtesy call to Imani Mo and see the Restoration Center for Justice there by the Nakuru Leadership Christian Fellowship. You must also take time to look around, I think they have a lot of things to showcase in Nakuru. So I must also thank the county government of Nakuru, the Nakuru High Court, and the leadership of the Kabarak University. Even Egerton University participated in co-hosting this event, as well as everyone, all the partners that have been named by Professor Ngoge, who came to support and make this conference a resounding success. For us in the judiciary, this conference provides an ideal opportunity for animated conversations and exchange of ideas on how we can accelerate people-centered justice in Kenya and beyond, as we have heard from our brother in Uganda, what they are doing, and we have keenly followed your speech so that we can borrow those best practices. This is the third AJS conference that we are having in Kenya, after we had a very successful 2 conferences. And I'm eager with anticipation to see the innovations and game-changing initiatives that will emerge from our deliberations on how we can accelerate, engage, expand, and retool AJS in Kenya. As the times become more uncertain, assured access to justice remains a modicum of hope that we can cling to make our societies more peaceful and more cohesive. Stories have been told since yesterday when we convened to open the Restoration Center and the dinner we had last night of how effective AJS is in restoring peace among family and communities. Those stories have continued today because justice is both a process and an outcome. It recognizes the protection of all Kenyans and offers vindication, restoration, and restitution of harmonious social ties. When we recognize there is healing and there is power when people resolve their own disputes, that is when we will truly realize the social transformation promise of our Constitution. Within this context, many speakers have spoken about the justice gap, which rears its ugly end. The empirical reality of this view in our country came when we did the Justice Needs Survey in 2017. And this is why when we were conceptualizing AJS and even our social transformation through access to justice, all the justices, and I'm happy many of you turned up, we asked ourselves, if it's only 10% of the Kenyans who can approach and settle their disputes through the formal justice system, then which justice are we dispensing? What kind of judges are we? Are we judges only for 10% of Kenyans? We went further and saw that from that report, 71% of persons with justice needs went to alternative avenues of dispute resolution. What was most shocking is 19% of the Kenyans with legal problems and serious violations of their rights did not take any form of action to resolve or seek any remedy. In other words, they died with that violation, or they lived with the trauma of that violation. And this is why, as a judiciary, we decided that we will look out for that other 90%. And we will work with that other 90% by breathing life and spirit to all the alternative justice systems, be it court-annexed mediation, which has really taken off, be it ADR, and that is why the last year we had a very, very successful conference with the Kenya National Bankers Association to see how we can expedite disputes within the banking industry. And we talked about early warning signs, and I'm happy Mr. Gichora is here to tell us the successes of embracing AJS in the banking industry, that now 7 billion has been returned to the economy. So the justice gap is not only just a problem in Kenya, we have heard also in Uganda is the same 10%, but it's also a global problem. More recently, the Task Force on Justice for All, which is an initiative by the Pathfinders for Peaceful, Just and Inclusive Societies, a global partnership which works to accelerate delivery of the United Nations Sustainable Development Goals and their commitment to provide justice for all by 2020, outlined some grim statistics in their 2019 report. This Pathfinder Task Force reported overall 5.1 billion people, that is 2/3 of the world's population, lack meaningful access to justice. And this is why we Kenyans have said we must own our own problem. And the problem we are owning is the gap between access to the formal justice system by embracing the alternative systems so that we can resolve our own justice gaps. Because as many speakers have said, we know the source of our problems. We know the solutions for those problems, and we can resolve them. Last night we also said, although we were caught up by the Spirit, we were speaking more in the spiritual realm than in the natural. But even within that spiritual realm, we said there is no problem which is big, and there is no problem which is small. The solutions are within our hands, both for the what we call small problems and what we call complex problems. We have the ability to solve them all. And last night we were given all the backings from the Bible on how the Bible instructs us to solve all those problems, because we are representatives of God. We bear the DNA of God, and we can solve all those problems. So while people in all countries are affected by this justice gap, the burden of this injustice is not randomly distributed. The people who bear the brunt and the burden of injustices fall too heavily on women, on children, and other vulnerable groups. Am I talking to somebody? These are the people who face the hardest struggle to access the justice system and to exercise their rights. And therefore, we have said under AJS, we are complementing each other. Although there are matters that cannot go to AJS, the champions of AJS are there to guard our society against any form of violations. Just last week, we were in Moiben. Thursday last week, we were in Eldoret, was Gishu, where we launched 6 AJS suites to function for that community and access justice to that community. We also launched a court in Moiben so that people stop traveling long distances. You may be surprised, honorable delegates, to hear that Uasin Gishu, which is, I think, the epicenter of politics, and only one court in Eldoret. And so now we opened another one in Moiben, and we are going to open another one in Talbo, and we are going to Sambasa Justice in that county as well. So what the people of Uasin Gishu said, and I hope it can also be the resolution of the people of this great county of Nakuru that set standards for everybody, is that in our communities, no one will violate another. Cases of gender-based violence, we are not even able to call those names sexual gender-based violence, because when we called a court that name, the same people told us this name is stigmatizing. So why are we committing this offense which we can't even mention? It's an abomination. So they said, let nobody be charged in this court with the offense of sexual gender-based violence, because we can resist it, we can stop it, we can avoid it, and we can make our community, we can make our families, we can protect them from gender-based violence and make sure that even if we are complimenting each other, those are some of the cases that will never be dealt with at AJS, because there can never be justice, especially for a child who has been defiled, for a woman who has been raped. The law does not even allow us to discuss that. So for that area, we decided we'll be complementing each other, because NJS people are the same ones in the Court Users Committee. They are the ones who will be supporting our victims if they are coming to court, to make sure they come and seek justice. Can we say amen to that? That we will protect our society. We will say no to gender-based violence in our families, in our communities. We will protect our children. So we will work together, and the judiciary, as we implement our vision, the social transformation through access to justice, which seeks to position the judiciary to contribute towards the realization of social justice aspiration of the Constitution through adjudication of disputes, facilitation of justice dialogues, connection of justice champions, and promotion of social harmony. We have recognized we in the judiciary are not judges to sit on the bench and listen to cases, but we are supposed to ask ourselves, like the fisherman who was downstream and the fish were coming downstream dead, what is causing the death of the fish? So as we sit in the bench, we are the connectors of justice, and we are the facilitators. That is why we are working together with the AJS, and we are working together with the court users. We are working with the bar and bench. We are members of the communities. We are judges. We are Kenyans. We must solve all our problems and make our country safe and secure for everybody to done. I think this is the 7th county. You remember the other day, we automated our systems. We were able to say let there be e-filing from all over the country. let there be virtual courts from all over the country. But Professor Joel Gogi, who is a thinker, who is a scholar, who is very clever, told me this cannot happen with AJS. AJS must be organically grown. It must be owned by the people. And that is why even the counties where we have not launched the action plan, we invited you so that you can go and start the fire. And then when you are completely organized, we can come and launch. So we are headed to Isiolo. We are headed to Ajil. And we want to come to every county. Last night, I even received the bishop from my county in Meru, who told me they are also organizing so that they are not left behind. So we want this fire to ignite in all the 47 counties, because we are eranding a people-centered justice system, and we recognize that we need to align our goals and operations with the needs and expectations of Kenyans we serve. We said we do not only serve the 10%, we want to leave no one behind. Therefore, we are focused on widening and multiplying the doorways of justice to enhance our effectiveness and to also augment partnerships and collaborations to allow Kenyans to be agents of their own justice. This is our conscious contribution to close and address the justice gap. Distinguished delegates, AJS and the AJS policy are very, very significant in ending and closing this gap. AJS is the detailed meaning of what the Constitution refers to in Article 159(2)(c) as traditional, informal, and other mechanisms used in access to justice in Kenya. AJS is a mechanism that deeply ingrains or is ingrained in our cultural fabric that communities across Kenya understand and practice since in time immemorial. It is a system we have utilized to resolve conflicts. And these range from Council of Elders in many ethnic groups who negotiate settlements among aggrieved parties and reconcile them. They enter agreements. They include this organic restorative justice within the communities, and we are tapping that very good practice. And once these mechanisms are aligned with the Bill of Rights, because as everybody has spoken, including Her Excellency, the Ambassador of EU has told us, we must always ingrain the human rights in whatever we do. Recently, I was invited by the Commonwealth law ministers when they had their conference in Zanzibar to speak about AJS. And their worry was our customary practices are embedded with bad discriminatory practices that do not respect human rights. But they were happy to hear that AJS, which is provided for under Article 159 of the Constitution, is ring-fenced with the principles of respect of human rights and fair hearing, and it is not at all inferior to the practices we use when we are in court. We give an opportunity to everybody to hear their view. We include everybody in the community, and we come up with an agreement that is understood by everybody and signed by everybody. Then we adopt it in the court, as the order of the court. So it is not at all inferior from the orders that we issue in court. So for us, we are on the right track because we now have AJS action plans in Kajiado, in Nakuru, in Mandera, in Turkana, in Narok, and Uasin Gishu counties. This is in addition to the launch of AJS Ukumbi Suites in Kajiado, Nakuru, Mandera, and you have heard the successes of Mandera, the inclusivity of AJS that we have even recognized a 7th clan in Mandera, and they sit in these ukumbis. We have an ukumbi in Samburu, we have in Turkana, which we launched. I was there. We have one in Ramu. We have in Uasin Gishu, Moiben, Talbo, Keses, Ainaboi, Kapsalet, and the Soy. We are doing well. We can still do more and plan to do more to expand, to engage, and to retool AJS across the country. In my view, the social transformation through access to justice gives us a formula in the chapter on situation analysis, where we said, firstly, even as we expand, engage, and retool AJS, we should own ground. This is why wherever we go, we never leave. We hold ground. Ni kushikilia kabisa wherever we go. This entails acknowledging and accessing our assets, which include the various action plans, the Ukumbi suites, NJS centers, elders, and justice champions. We must never neglect these assets, and we must do our utmost best to ensure they thrive. We keep a record of what is happening in each of the Ukumbi. Secondly, we must advance ground. This means that we must fill the deficits that we have identified as we champion the NJS cause. We must be conscious of the user feedback and the increasing demands for justice. We are also bearing in mind the high cost of formal justice mechanisms and any other challenges faced. Lastly, we should look forward. We should bear in mind that Kenyans, be they court users, communities, women, youth, council of elders, county governments, academia, and civil society organizations, are all seizing opportunities to participate fully and prominently as justice sector, as justice actors. And I'm also happy to hear what Kerin is doing and the number of cases they have been able to settle within their own framework. How I wish, and I believe in the course of this conference, we will hear more from other actors. Finda will also be telling us the number of cases they have been able to settle, and so are all the other civil society organizations. That is the beauty of AJS. We all belong. So let us continue to empower these civil society organizations. Let us put people at the center as we analyze a transformation and ask ourselves, how are we impacting and making the society better, even as we work as justice actors within the formal and also in the civil society movement. Let us improve NJS capabilities in a sustainable way. Let us utilize evidence-informed practices to deepen access to justice. This is also evident in the first autonomous AJS center in Africa that we opened in Nakuru town, led by the Nakuru Church Leaders Platform yesterday. This is the power of people owning and utilizing their agency to resolve justice problems. We have said, and everybody here who spoke this morning said that justice is a lived experience and therefore belongs to all of us, while the judiciary plays its constitutional role of ensuring that we deliver justice. The people themselves are our key partners, they are our key stakeholders, and they are the agents for their own justice. I am certain that we will continue to innovate approaches that enhance access to justice to all the justice seekers. To conclude, I wish us all very fruitful deliberations. I want to thank each one of you for the sacrifices you have made to attend this conference. I know it is such an effort for people to travel the distances you have traveled and to find their way here at the Kabarak University. I thank you all, and God bless you all as we continue with the conference. And with all the powers bestowed on me as the Chief Justice and all other titles that I carry, I declare this conference officially opened, and wish you all.
Please, let's appreciate the Chief Justice. Again, let's be upstanding. Thank you, Chief Justice, for those remarks. Thank you very much. Let's be seated. I know it has been a very long morning, but it has been worth every single minute of it, isn't it? I want to thank the Chief Justice for taking time to be here. The Deputy Chief Justice from Uganda, Asante Sana. The judge to your right is your neighbor from Busia. That's where he comes from. The judges who are here just stand up to get a sense of how many judges are in this congregation. I'm not making them stand up because some have been sleeping. That's a joke. Let's clap for our judges. Thank you very much, honorable judges. Thank you for being here. Now, I would like to invite Jemima to come and make a few announcements on what happens immediately after this, and then we'll take it from there. Thank you very much.
Tumpigie makofi tena. My lady, all protocols observed. I'd like to use Swahili a little bit. Properly set precedence jana. Yeah. Wakati wa kutazama na kushuhudia jinsi njia mbadala za kupata haki umefika. Tumekuwa tukingojea ama kusubiri kwa hamu na gamu wakati huu. Najua kwamba tumejiandaa na pia huu ni wakati wa kujivunia utamaduni wetu, ndiposa sote tumeweza kuvaa katika mavazi ya kitamaduni. Today the people who wameshine sana are from tuwapigie makofi. Wandera oye! Toka mashariki hadi magharibi, kusini hadi kaskazini, tu tayari kutembea kwa kila hema, tuweze kuona jinsi tumeweza kutumia njia mbadala za kupata haki na pia kuona jinsi tunaweza kutumia njia hizi kueneza injili ya amani kama vile tulivyoelezwa jana na watu wetu wa kidini hapa Nakuru. Waliojitokeza ni kina nani? Trans Nzoia, are you here? Mandera, are you here? Nakuru AJS Working Group, FIDA Kenya, Kelin, Pamoja Trust, Malaika Foundation, Egerton University, Kabarak University, Natural Justice, National Council for Law Reporting, National Legal Aid Service, grassroots organizations operating together in sisterhoods, Nakuru AJS Mashinani, and then we have Iraq. My lady, these are the people who have been able to prepare for the exhibitions. As you said, we have statistics from different institutions and county governments and also civil society, and they're ready to showcase how innovative they've been able to implement Article 159(2)(c), not only in regard to the cases or the disputes, but also other ways of enhancing peace in their spaces. And so, my lady, this particular time, we want to invite all of us to be able to see what the exhibitors have in store for us. And we are asking all of us to be able to proceed to the amphitheater. After the group photo, we are able to walk from one tent to the other to showcase, to be able to witness what the exhibitors have been able to prepare. Hadithi hadithi, zamani za kale. So my lady, we've also prepared a fireside chat in the evening. We shall be able to have our elders sit with us. We learn, take us back to our roots. How were disputes resolved? What is it that they used to do that we left, ambayo ilituacha, ama hema ilituachia wapi, meli ilituachia wapi? So we'll be able to sit with our elders, learn from them, different ways of resolving disputes and enhancing peace. And this is one of the to sit with us to kichoma mahindi and just learn about the multiple door approach that AJS is giving to our communities. So my lady, allow me to give us the orders for this, the program for this particular session. After this, ladies and gentlemen, we are all going for a group photo, and we shall have a tree plant session. After the tree plant session, we proceed for lunch. During the lunch, we start the exhibition. It's organic. There's no order of saying we move from this tent to the other. It's going to be very organic, and the people are all ready to showcase their work. Thank you, my lady, and we invite you for this particular afternoon session. Shall we all rise up for the national anthem? And we be seated as we start with the first row to step out and to be guided. Okay. Okay. Yeah, so we'll all be seated after that, and we allow the first row. Protocol team, I hope we are ready. I'd like to invite Justice Mtuku to give us the closing prayer, and then we do the national anthem. Reverend Mtuku, please.
Let us pray. Heavenly Father, we thank you so much that indeed creation is the product of your work. And you are very involved in every detail of creation. We thank you for the unique mandate that you have given us as humans. And we are grateful that we can have conversations across the boundaries so that we can enhance the very fact of our existence through justice approaches. We are grateful for the many speeches that have been made, ideas that have been exchanged, and for the future that we look forward to. We pray that you may lead us into that future as you guide us through the justice path for your glory. Even as we come to a close, we pray for our guest, the Chief Justice, and the entire team of our guests, even the Deputy Chief Justice from Uganda, that as they will be journeying back to their places and destinations, that your journey mercies will be upon them. Even as we continue with this conference, we pray for the remaining days,